So give a hand for Brenda Reedy.
Thanks. Yeah. Can you hear me? Is it on? Okay, great. Well, nobody told me I was following Doug. Oh my gosh, and then I'm coming up here to talk about discipline, right? Such a lovely light topic for right away in the morning. So welcome everybody. It is so good to see a lot of familiar faces. For those of you who may not know me, I'm the HR manager at Wyoming Department of Corrections. And I think I was selected for this topic today because I probably process, I don't know, about 110 or 20 disciplinary actions a year. So we're doing discipline about every week. We have grievances, 2 disciplines a week, 1 grievance a week, a few hearings here and there, right, Sue? So I thought I would talk to you and share some of my insights over the years of being in state government HR between my time at the state hospital in HR and also with corrections. I kind of fit with that institutional location, I guess. I'm at 18 years now, so got a little bit there to talk about. So think about your typical day. You're coming into work, sitting down. You're like, oh, you got your day planned out. I'm gonna get this done and that done, get some PMIs approved. And then you get the call. And you're like, oh, there goes my day. Hello, Human Resources, how may I help you? Hi, Brenda. This is the manager. Oh, hi, manager, how you doing? Well, I have a problem. Oh, okay. What's your problem? Well, I got a complaint. Oh, okay. What complaint did you get? Well, we were doing physical fitness testing this morning, and one of our trainees showed up in his kilt. Okay. Not something I would normally think would happen, but okay, it's not necessarily a violation of the dress code. So what's the problem? Well, the supervisor, they were running, he decided to refer to him as Kilt Boy. And now I have a complaint. Okay, Kilt Boy, what do you automatically think? I know I got labor standards people in here. Yeah, okay, that's ethnicity, right? Oh, crud. Now what do I do? So, first things first, what really did happen? So, supervisor, what have you done? What have you done so far? Well, the employee came up and complained. All right, so we need to find out what really happened. Now, in Department of Corrections, we use what's called staff reports. So if anything unusual happens or I'm involved in an incident while at work, they have a form they have to fill out that explains what happened. So for me, my first step is going to be, get me some staff reports. Who all was involved? Well, the supervisor was there, the employee, and about 5 other people. All right, then you need to get me 7 staff reports. Let's get some documentation, and then we'll figure out where we go from there. So I now have a performance issue and a complaint in front of me. And it's going to fall into generally one of these types of performance issues, and probably more than one in this particular case. So when you look at your performance issues as an HR person, it's either going to involve violating policies or procedures, maybe poor work performance. You're going to be looking at behavioral or conduct infractions, which is right up this particular situation's alley. And then you also have your absenteeism and tardiness. So you're going to be addressing issues kind of in these 4 realms in general. They're going to probably fall into one or more of those categories. So the manager and I start talking and we say, okay, we need to get some documentation and find out how we need to address the supervisor who made this statement. So when I get my documentation, there's a lot of different things I could be asking for or looking for. So the first one, we could be asking for reports, like our staff reports. Maybe there might be an investigation out there. This Might be a situation that does need to be investigated depending on the information that comes in. So manager sends me in the staff reports, and we start looking through them. One of the questions I might ask the manager is there anything else? Is there any other information you're aware of that we need to consider as we look at this situation? Other things that you might ask for would be your handwritten or typed notes of staff. And by the way, I see a lot of people making notes, and I can share my slides with you. It could be any emails summarizing your discussions or emails between staff. You could look in Halogen. There could maybe be some things in Feedback Central or in the performance evaluation that can be used as documentation. Any letters, counseling, discipline, corrective action, letters of commendation, we use those in corrections. So a letter of commendation might influence how you maybe look at this issue depending on what that's about. So looking at all this documentation and asking for these things is important so you can see the whole picture. So get the staff reports, and what are you going to be looking for? So we're going to look for, did they cover everything? Do we know who, what, when, where, why, and how? Now the why isn't necessarily going to come from all the people who saw it. The why is probably going to come from the person who did it. Why did you make this statement? Why did you call this employee kilt boy? So we're going to be looking for that in our documentation. And if we're not getting that detail, then we need to coach back to the manager or whoever to say, hey, I need to get more detail about this. Quotes are really important. If you know what the person said, let's quote it. If you get the documentation and you read through it and you read the supervisor walked up to the employee and they referenced their kilt. Does that change how you might view the situation? If you're looking at the documentation and all it says in there is they referenced their kilt, that could mean they said, hey, I like your kilt, right? It could mean a lot of different things. So you want to make sure that it's accurate. And if what he said was kilt boy, then having that in quotes changes how you're going to view the situation. It's more factual, it's accurate, and it then helps you decide what action you're going to take. So if someone is saying they said something, it's best to use those quotes if you know that's exactly what they said. Certainly be objective in that documentation. You know, we see a lot of staff reports with different things written in them. And, you know, let's say the employee wrote in there, yeah, that supervisor's just a jerk. He always treats everybody like that. Great. Is just a jerk an objective statement? No, that's an opinion, and that's a subjective statement from that person. So what I'll need to do when I get that documentation is go back to that employee and say, hey, you know, you're saying that this person's just a jerk. What does that actually mean? What does he do that you perceive as being a jerk? And get that specific detail from the employee. You know, it's like calling someone lazy. Lazy means a lot of different things to different people. So what is it that they do that's lazy? You know, oh, well, they sit and watch, you know, their phone all day, and they don't do their work, and they always miss their deadlines. Oh, wait, that's the objective, factual stuff. The lazy is an opinion. So he's just a jerk all the time. Oh, well, why is he a jerk? Well, he always goes around and yells at us and uses foul language. That's another one that I struggle with. Okay, what foul language? Because if they said shit, which was used earlier, you know, that's going to be viewed a little differently than if they're dropping the F-bomb. I know, Doug. So that saying, you know, use foul language, we gotta find out what that foul language is and be more specific about that. I didn't hear it. I didn't hear you, sorry. Oh, great! Well, you'll know how we're going to write your discipline then. Just kidding. So, and then finally, when you're looking at that documentation, you want to look at potential organizational impact, if it's there. You know, so if, especially in corrections, if anything could jeopardize the safety and security of our facilities, you know, that's going to make a huge organizational impact. Like we require our staff to log if they take out tools. That way we know if there's a tool out in a prison, we know who has it and where it's at and all of those things. And let's say someone forgets to log. You know, what's a big deal? You forgot to put down a date and a name on a piece of paper. But let's say someone goes to look for that tool and they can't find it. They go to the log, nobody logged it out, and we have a missing tool in a prison. That could be a big problem. And so then they're like, okay, we got to lock down. We got to do searches. We got to find this tool. And here I am over here just, you know, working away, not even paying attention. And then they're calling for a search. And, and suddenly I've impacted the whole operation of the prison because I didn't write a little line. That's a huge impact. And so when we go to look at taking action, we're going to take into account what their behavior did that impacted the operations or the organization. So those are things you're going to be looking for in your documentation. Another thing you're going to do is you're going to make sure you have all sides of the story. I have supervisors all the time call, I have this problem, I want to throw the book at this person. I am so tired of their behavior. Okay, what'd they do? Well, they did all these things. Okay, and what did they say about it? Well, I haven't talked to them. Okay, so how do you know they did all these things? Well, I heard it from everybody else. Okay, we need to get their side of the story. Because let's say we take disciplinary action on someone and we didn't get their side of the story, and we sit down and we're like, we're disciplining you, we're throwing the book at you, here's the problem, you're getting this discipline. And they're like, well, that's not what happened. What's your next thing that's going to happen after that meeting? Anybody? Yeah, you're going to get that grievance and have to then go through and get all sides of the story and then take action to correct that problem. So, get all sides of the story up front. Make sure that the action you're taking is well documented and you know that the action you're taking is supportable. Certainly fact check as you're looking through things and verify all the facts of the matter. You know, we get a lot of investigation reports from our internal affairs department, and they're lengthy reports. And so sometimes you have to really comb through them to say, okay, what did this particular employee do? Yeah, they substantiated bad behavior, but I need to pull out the specific facts of what they did so that I can discipline them on that. You know, because usually our investigations involve a lot of people. So there's a lot of different employees you have to pull information out on what they did specifically that was problematic. So make sure you're checking for your facts and pulling those specifics out so that you can discipline them on what they did. Employees don't like it very much when you discipline them for stuff other people did. So just avoid that. Certainly proofread and spell check all your documents. Remember that these documents could end up in a hearing in court, so make sure that they are correct in how they're presented. One of the things that opposing counsel or opposing staff, if you ever have to testify, they'll tear apart any errors that they find in your documentation. And okay, well, what's this error? What's that error? Why is this a problem? If you made errors here, what other errors did you make that we don't know about? So making sure you just take that extra little step to proofread and avoid errors. Then you avoid the, yes, I made an error testimony that you've had to do. And then try to be, oh, I don't know what I did. Sorry, I need to quit waving my hands around. I do talk with my hands. So, so you can avoid that. And then finally, with this particular slide, make sure you're using complete sentences. That's easier to be clear on if you have complete sentences rather than bullet points. And then email, just remember that's evidence if you have email. In our particular case with Kilt Boy, let's say after the incident occurred, the employee didn't complain immediately, but went back to the supervisor and said, hey, I didn't like the fact that you called me Kilt Boy. That was really uncool, man. And later, the supervisor goes back to the employee and sends him an email and says, quit being such a whiny baby. You need to grow tough skin. Okay, now we have an email from a supervisor saying, something, quit being a baby, you need to grow tough skin. So now in our situation that we're looking at, we have the supervisor making a statement that he's Kilt Boy, and now makes a reference to him being whiny and needing to grow tough skin. Boy, tough skin, kill. Now I'm looking at possibly 2 issues that labor standards would be all over. We're talking gender, there could be some gender discrimination issues going on, and there could be the ethnicity issue going on. So now we've got an even more serious situation. So if you didn't ask for all that documentation and get that, and then then the employee has this little email, trots down to go see labor standards and says, look what they did. They called me Kilt Boy, and then the supervisor sent me this email. I'm being discriminated against. And then you're getting the EEOC claim. So, or the Wyoming Fair Labor Practices Act, whatever that one is. So make sure you're getting all that documentation so you don't get those little surprises. All right, in your documentation, make sure people aren't putting their personal or professional opinions in it. Sue and I had a fun hearing a few years ago, and one of the supervisors, it was a challenging employee. It really was. And one of the supervisors kept putting her professional opinion about this employee's fitness for duty in staff reports. I'm like, what is your professional opinion about their ability to do the job when you're not a doctor, So it kind of made it a little challenging for us, and we had to then be able to explain that stuff. Or I love it when they make a complaint or they say, oh, this happened and this employee's in a hostile work environment. Great, now they just gave an opinion on, a legal issue, which would fall under harassment or discrimination. So now I have to look at this as a potential violation of workplace harassment or discrimination issues. So make sure people are not putting in those personal or professional opinions in your documentation. Certainly avoid any derogatory remarks about people, For us, I threw inmates in there because people sometimes do make negative comments about inmates, and that makes it sometimes difficult for us. Don't summarize those important topics. Be clear. When they say, oh, and he made this statement, and then we all went home, and it's like, wait a minute, something else had to have happened in there. We need to find out everything that happened in that particular issue. And then certainly, don't put in your attorney-client opinions or legal conclusions, like a hostile work environment, in your documentation. In that one hearing, we had the supervisor also, because I'm counseling her, and I'm like, well, I talked to the AG, and here's the next steps we need to take. So of course, in her staff report, the next time he did something that she was supposed to document about, she writes at the bottom, and Brenda Reedy said, the AG said that we need to document this. And I was like, oh, okay. Now we don't have that attorney-client privilege about that conversation. So that becomes challenging. So avoid that type of thing. And then certainly when you're looking at your documentation, remember that it's going to help you recall specific details down the road. when you think about our disciplinary process and grievance and appeal process, when you're in court testifying, it's most likely going to be at least a year past when the behavior actually occurred. By the time you get through the disciplinary process, and then you go through the grievance process, and then they take it on appeal, and if they take all the maximum deadlines, and then by the time the hearing is scheduled, and you do all of your discovery and all that other stuff, and you actually get to testify, it's a long time. It's a big process. So if you don't keep good documentation, and good documentation of your own conversations, that's another important part, because as I'm talking about checking the documentation you're getting, make sure you're keeping your own. Yes, I talked to the supervisor about this. This is what they reported to me. This is the guidance I gave them, because that's most likely going to be what you're going to be testifying on in the hearing. So make sure you're keeping good notes of all of that information yourself and keeping it with that particular documentation for that issue. Certainly, the documentation also demonstrates our decisions. We can sit there and say, here's what we had, he did these things, it's very clear, now this is the action we took. So it helps in that way. It also adds validity and credibility to you as well as anyone else who's involved in the situation. There's nothing worse than being sitting there testifying in a hearing and they ask you a question and you're like, I don't remember that. I don't know. Well, did this happen? I don't know. I don't know if I remember that, you know? And so now suddenly the hearing officer or whoever is part of that, they're going to be going, well, if you don't know that, what else don't you know? You know, why are you even here if you don't even know what's going on? So knowing that you have that documentation, you go back, you review it, and they ask you a question, you're like, yes, that happened. No, that didn't. Yes, that happened. And Sue, I'm learning just to say, yes, that happened, and not explain what happened after that, because you're not supposed to do that when you testify. Don't be too helpful. Being able to do that will add that validity and credibility to you. It also focuses your discussion so you don't go off topic. And then obviously it's going to be your evidence as well. So, any questions about documentation? You guys are so quiet. Okay, I've never been in an HR room with so many HR people. It's so quiet. Okay, Anne.
So, when you start to compile the documentation, where do you keep it? Do you put it in your personnel file? Do you have your own file? What does the Department of Corrections do?
I keep a separate electronic file of all of my actions. So, like, I will have, for each year, I have each institution, and then under each institution, I have the employee issue, and in that folder is all the documentation, the action we took, any follow-up, I mean, everything's all together. And then I'll scan and save my notes in there too. So if ever I need to get to that information again, it's all right there. Yes?
Do you keep a log of what's happening so that you can go back and say, okay, this is what we did, and how do we...
Yes, we keep a... Oh, certainly. Okay, so Anne's the first question was, what do you do with your documentation and how do you keep it? And Raquel's question is, do we track what we do? And the answer is yes. I got to get with ETS and get a little more techie, but right now I just do spreadsheets for each year, and we track, every action that we took. And for grievances, it's easy because A&I sends us a spreadsheet that we have to complete every year. So I just track grievances throughout the year on that spreadsheet. So yes, that way when we're looking at taking action and as we go into the slides, it'll help you when you're looking at consistency. So yes, we do track that. And on my tracking log, I put in there like the date of the action, who it involved, what action we took, and then kind of a general summary of the behavior, and then, what policies they violated, what was their previous history, because that obviously influences what you do, and then what the final outcome was.
So for, you get into the hearing side of it, so we've done all the internal, so it's serious enough to go outside of this. Have you ever experienced where your documentation has been subpoenaed as part of the official record?
Yes, we did have that, didn't we, Sue? Repeat the question. So, have you had your documentation subpoenaed? And the answer is yes. Well, not necessarily subpoenaed, but through the hearing process, there's discovery. So we have to put together all of our documentation and then share it with the opposing side, and anything that we would present at the hearing would need to be provided. And that can be a lot. I would say all the instances where we've gone to hearing are exhibits of each individual document that we've provided. Gosh, it went up into the double vowels, A through Z plus, a few more doubles after that. So it's usually a lot where you have to provide that through discovery. So, okay, yes?
So Brenda, when you keep your own documentation like that, do you also keep the documentation from the supervisors?
The question is, do I keep the documentation from the supervisors along with my own? If the supervisor provided me with supervisor notes on what they did, I'll keep that with the folder with everything in it. And then it'll just be there. If the supervisor says, hey, I had these conversations, but I don't necessarily have their notes, then the supervisors keep their notes. I don't necessarily keep them. We do have in our policy where if after an employee leaves and the supervisor has their supervisor notes, we ask them to send them to HR and we maintain them for 5 years. And then if nothing else happens with that employee, then we'll shred them. But that's what we do. I don't know why, but what's my time like? Okay, all right, because I still have another half of the presentation to go. So any other questions just on documentation? Now, I'm really working on moving toward electronic personnel files, which will be really fun eventually, but we're just not quite there yet. All right, so now we've got all of our documentation, we've reviewed it, we've checked it, we know we need to take some action. So what action do we take? I mean, there's a lot of different options that we need to look at. So when you're looking at taking action, obviously there's 2 types of employees in state government, at least. I know there's probably a few more, but in general, if we're doing corrective action, it's probably going to be on either probationary or permanent employees. Now, certainly with probationary employees, they are at will, and they have no expectation of continued employment, and so we want to be careful that we don't treat them like permanent employees. So with probationary employees, there's really limited options. You either counsel them and give them expectations on what they need to do differently, or you dismiss them. I mean, really that's where we stay, just because we don't want to start muddying the waters and make it look like we're treating them like a permanent employee. Because if you treat them like a permanent employee, you could jeopardize that at-will status. Then certainly with permanent employees, they do have a property right to their job, and they have a right to due process. So with a permanent employee, you can't just go in and say, you're fired. We're taking your job away. They have a right to know why this action is being taken, why they're getting fired, have an opportunity to respond to that, and they also have an opportunity to appeal it and take it to a higher level because of that permanent status. So before you take any action, you always want to know what type of employee are you dealing with. And so types of actions that we can take, the personnel rules, chapter 7, they don't refer to probationary counseling, but that's all we'll do with a probationary employee. But for permanent employees, there's section 2, which talks about corrective actions you can take but aren't required. And then there's section 3 that says this is the discipline that the state of Wyoming authorizes. And it's in this type of order. We do progressive discipline with a written reprimand to a disciplinary suspension without pay for 1 to 30 days, so you got a lot of flexibility there, and then to an intent to dismiss or dismissal. Then if you need to skip steps, the behavior needs to be serious or egregious to skip a step. So we need to stay within, this kind of 3-step process, which can sometimes turn into 4 or 5 steps, depending on the situation, unless there's reason to skip a step. So when you're looking at what to do, first thing you want to look at is the severity of the offense. So with this supervisor who referred to the employee as kilt boy, and we verify that that's exactly what he said, and then he later sends this email telling him, you need to get thicker skin. And, how severe do you think that offense is? Is that corrective action, counseling worthy, assuming that, he doesn't have anything in his history, or is that disciplinary? What do you guys think? How many think corrective action? How many think discipline? How many didn't raise their hand? Most people didn't even raise their hand. So the severity of the offense, for us in Department of Corrections, we do have a zero tolerance policy for any type of behavior that is considered harassing or discriminatory or anything like that. This particular situation, given the language and the slur and all of that, it would violate our policy. And because we have a zero tolerance stance, we would go to discipline on this. Other agencies might look at it a little differently. So we're going to have to look at that. We're going to have to look at the impact on the agency. Certainly, if we get a claim and we have to do an investigation and things like this on the comments, then that might have a bigger impact on the agency. Or if, let's say, we find out he's a really big jerk and he is making other statements that are inappropriate, then that might have a broader impact. It might affect more people, have a broader impact on the agency. So we got to look at that. Certainly in my example of tool control and not, signing out that tool, that had a big impact on operations. So we're going to take that into account, and that could be a disciplinary type action just because we had to lock down and search and all this, and it affected so many things, and we're short-staffed as it is. So big impact. The employee's past performance record. So we're going to look at their PMIs. We're going to see what's in there. We're going to see, is this a pattern of behavior or is this a one-time thing? Certainly we're going to look at their length of service in this particular issue, because this is actually based on real life events. The particular supervisor had been a long-term employee. So he knew better. He knows our policies. He knows things. And, in this particular instance, he just thought he was being funny. But it didn't really get perceived that way. So we're going to look at that and say, hey, you knew better. You're a supervisor. You made these comments. That's going to raise it to that disciplinary level. And then we're certainly going to look at our agency past practice, which is what Raquel was referring to with having a log of what you've done and why you've done it. So you can look at how have we treated other people who've done similar behavior in the past with a similar background. And then certainly we're going to look at progressive discipline. So has this person been disciplined for this type of behavior or similar behavior before? So we're going to look at all those things. And then we're going to write the action. The personnel rules, Chapter 7, do have requirements for discipline and what needs to be in the letter. That would be the reason for the action. It would be that if they are suspended, then the dates of that suspension. Any previous corrective or disciplinary action, any unacceptable performance appraisals, any discussions that have been had with the employee, the corrective action that's needed to avoid further discipline, and then the right to present a grievance. And I just have to point out that last section, the right to present a grievance, that's really important. Make sure you put that in there, because if you don't, then you have to start over. And, obviously many of these examples are from personal experience. So So we have to do that if we are disciplining at a reprimand or suspension. If we are doing a dismissal, it's a two-step process. So we're going to tell them our intent to dismiss them. So we have to give them that reason why, and that they have the right to respond within 10 days to our reasons for dismissing them. And then I put ARL in here just because if they're not already on administrative review leave at the time you give the intent to dismiss, then it is something you want to do at that time, because then they'll get paid for that 10 days and they will not be in the workplace. So you'll need to put in ARL language into your letter if they are not already on ARL. After the 10 days, if the employee does not respond, then you can move forward to the final dismissal. And in that, you're going to give the reason for the dismissal, the effective date of the dismissal, and the right to present a hearing. If the employee does respond, then you want to consider their response. And then if you decide to go forward with dismissal, then one thing you'll want to add in there is that they did respond and that you considered their response, and this is your final action. So there have been a couple instances where we have reversed our decision on an intent to dismiss based on additional information that the employee provided in their response. So it's rare, but it can happen. So we have a process for a reason, right? So, okay. All right, so when you're writing the action, Department of Corrections has pretty lengthy letters. I put a lot of effort into these letters because to me, I want the employee to understand what's going on and what they did and what they need to do differently. And I also want to write them in a way that if it does go to a grievance, someone outside of corrections can read that letter and understand why we took the action we took. Because if you don't work in corrections and you're just looking at, God, you disciplined somebody for not putting a line on a little log, why was that such a big deal? They should have just been counseled. But if you're in corrections, that's a really big problem. And we can't have that happen. It jeopardizes the safety and security of our facility. So, I need to explain to the employee and anyone else who might be reading this letter why this is such a serious issue. So I want to document the issue. I want to explain why the employee behavior is a problem. I want to be able to set those clear expectations, provide them with action items if it's necessary for them to correct their behavior, and then state the consequences. So our letters follow a particular flow. Like we'll start out with, hey, we're giving you a letter of reprimand in violation of Chapter 7, Section 3A of the State of Wyoming Personnel Rules. And we'll list the reasons why: misconduct, unsatisfactory work performance, violation of rules, all of that. And then the next section is going to be like, on this day, this is what happened. And I'm going to be clear about the facts of what occurred. And then after that, I'm going to tell them why that's a problem. You didn't log, we had to shut down the facility, it created a search, and it wasted, an hour and a half of time before we recognized that you had the tool, and so we're gonna make that clear as to why that's a problem. And then because Department of Corrections has a lot of policy, we quote all of our policy, because our employees can't remember 150 policies off the top of their head. So we quote the policy so they're clear. This is what policy said. You violated tool control. You violated, code of ethics. You violated, the executive order code of ethics and all these different things. So we're going to quote the specifics of the policy. And then after that, we're going to tell them, okay, going forward, oh, no, we gotta tell them what they've done in the past before we go there. So then we'll tell them, here's your disciplinary history and corrective action history based on what's in your personnel file, and we'll list that out if there's any. Here's what we located in your PMI that addressed this very issue, and so you've been counseled on this before through your PMI in 2015 and 2016 and 2017, and we'll quote what the supervisor said. And then after that, we'll tell them, now this is what you need to do differently. You need to appropriately log, you need to follow policies and procedures, you need to be a good role model, those types of things. So we'll tell them what we expect them to do moving forward, and then we end it with both any further disciplinary action or any further misconduct will lead to further disciplinary action up to and including dismissal, and you have the right to present a grievance. So don't forget that. So that's kind of how we lay out our letters in Department of Corrections, and then it covers everything and it's clear, not only for the employee, but for anyone else who might read it. Some things to avoid, and I see this a lot where supervisors, and usually in counseling forums, they put the burden of what the employee's supposed to do on themselves. Do you guys ever see that? You need to do this differently, and I'm gonna follow up with you every week to make sure you did it. Okay, you just gave yourself that job. The employee just has to wait to meet with you, and you're the one who has to seek them out. And so don't put that corrective action on the supervisor. Make sure whatever the employee needs to do, they do, and they seek out the supervisor to, explain whatever they've accomplished. Don't make those disciplinary decisions in a vacuum. Make sure you're looking at the whole big picture of everything. You're looking at their previous history. You're looking at what you've done with others, and looking at the seriousness of the behavior and all of that. So if you just look at the one little issue, it may not look like you need to do something serious. But then when you look at the big picture, you go, oh, wait a minute, I need to take this up a notch. Don't make statements on their state of mind. When you say someone intentionally did something, they willfully did something, they were purposeful or deliberate in what they did, that just raised your burden of proof if ever you go to a hearing. Because now you have to prove not only did the behavior occur, but you also have to prove that the employee actually did it with intent to be, to do that. So avoid those statements if you can, because it's really hard to comment, unless you know for sure. Like, we had this one issue where an employee purposefully hid a tool to get somebody else in trouble. So there was intent there, and we could say that. But if you don't have that, and it's just with Kilt Boy, we don't know if he purposely called him Kilt Boy to be discriminatory or whatever. He said he was being funny, so maybe there's not intent. I think I saw a question. Oh, cool.
Sorry, so with regard to the statements on employees state of mind intentionally, willfully, what kind of evidence do you have to have for that? Like, is it an email that trail, or is it someone else hearing them plan for it? What kind of documentation do you want to have with that?
Right. Well, you will want to have the tool issue, we had him admit to, yeah, I did that on purpose because I don't like that guy. So, so you would have that. And do you want to hand the microphone to Sue, because she maybe can comment a little bit more on that kind of burden of proof for an employee's state of mind. Thanks, Sue, for letting me put you on the spot.
There's all different kinds of evidence, and what you just described was verbal evidence. A lot of people don't think that when somebody says something, that's evidence, but it is. So it's their thought process only verbalized. You have documentary evidence from emails, from staff reports, from other people overhearing the person describe their intent. Sometimes intent can be derived from the document itself. So let's say at the end it says, under penalty of perjury, I swear that on this leave form, I was in Rollins on Tuesday, and I stayed there for 3 days for work, but really they were there 1 day. They swore under penalty of perjury. That's intentional. Does that make sense? Yep. Okay, so if I answered the question.
Yeah. Thank you, Sue. Another thing you want to avoid is making those incriminating statements such as you've created a hostile work environment. If you don't know that for sure and the behavior doesn't necessarily rise to the level of the legal definition of a hostile work environment. In our kilt boy example, he had never done it before. It was, the one rude comment. He actually never sent the extra email. I just added that for effect. So really all he did was make the one comment. And when we looked at that, it didn't rise to the level of a hostile work environment. So I didn't want to necessarily document that we had one, right? Because now I've now set us at that standard and that level. So just avoid making any kind of statements like that. And then don't forget to review your performance appraisals, and because that may decide your level. If they've never been commented in their performance appraisal about this, and this is the first time, then okay. But if, 2015, we had to talk about how you approach people and how you communicate and that you use negative statements, and then we did it in 2016, and we had to talk to you about it in 2017, and now we're in 2018, and you're still doing it, that might influence going to that disciplinary level. So really review all that past performance. All right, so you've got your action, and the employee's now mad. Thanks a lot. I don't like this discipline. It's too long because, we have long letters. And, I don't agree with it. I'm going to grieve it. So this is our grievance and appeal procedure. How am I doing on time? So how much? 20 minutes. Oh, I have 20 minutes. I'm talking fast. I timed this yesterday, and it was like an hour and a half, and I was like, I don't know how I'm going to get this done in an hour. So whew, I'm glad I'm nervous. I can talk fast. So in our grievance and appeal procedure, first the employee submits the grievance within 10 days of the meeting. You have to have a personal conference within 10 days. Following the personal conference, the director gives a response within 5 days. And then, if they don't like that, then they can appeal to HRD, go to a grievance committee, and then based on the findings of the grievance committee, then you can end up in OAH. So how many have participated in a grievance committee? How many are interested? Because I need to get Tricia a name by tomorrow. Seriously, if you're interested, let me know. Yes. So Tricia is saying she would love more HR people to be out there and involved in grievance committees. So what happens when you're on a grievance committee? Because, well, first off, I want to just talk briefly about what we do in corrections in responding to grievances. First, you have your disciplinary letter, then the employee writes their grievance. And sometimes they throw things in there and you're like, I had no idea that was going on, or I don't know why that relates to this issue, but okay, they're concerned about whatever's going on. So when we have the personal conference, we like to make sure we talk about everything that's in that grievance letter. Then when we write our responses to that grievance, we like to make sure we close any loops. We don't want to leave any questions out there for later. So if the employee says, hey, I'm not happy about getting disciplined over this tool issue, and 5 other people did it and nothing happened to them, okay, well, we're focused on you, we're not focused on them. But then we might go look at what are the thems, did that really happen? And in making our final decision for the grievance response. And then as I'm responding to the grievance, I'm going to put in there, we reviewed not only your situation, but the other situations you brought up, and we found that that's not the case. Here's the facts that we found, this is what we're basing our decision on, and we're upholding the action, or we're reducing the action based on the new information, and we're going to explain all of that. And then, so the grievance letter can be fairly long too, because we're going to respond to everything that was brought up in that grievance. So that when it gets to a grievance committee and you're sitting down looking at the written record, which includes the disciplinary letter, the grievance letter, and the grievance response letter, That's usually your written record. That's it. Now, you can ask for more information and if you need to, but I prefer to make sure that whatever that documentation is that you're getting, you can read it and understand it, and there's no outlying questions. So even if it's something that didn't relate to the discipline, but it was in the grievance letter, I'm going to respond to that. Because if I don't, then that's going to leave a question for later down the road. And so when it comes to you in a grievance committee, you may look at that and go, well, did those 5 other people do the same thing and not get in trouble? If I don't respond to that in my grievance response, it's not part of the written record, so you don't know. And then that might sway you as a grievance committee member to say, well, maybe they shouldn't have been disciplined. If other people did it and they didn't get in trouble, why is this person getting in trouble? So make sure as you're doing your grievance responses that you are closing any of those loops. You're answering those unanswered questions so that when it gets to that committee, it's clear what happened, why we upheld the action, or why we, reduced it, but it was still, they still didn't like it. Sometimes we have a suspension where maybe we'll go from 3 days to 1 day in our grievance, and then it goes to a grievance committee, and then they're not happy, they're still suspended, even though they got 2 days back, so they can take it to the next level. So, so when you're serving on those grievance committees, it's important to remember all these things about why we take the action we take. So look at that big picture. Make sure you're looking at the fact that the employee might have previous history in that particular area. And if it's similar behavior but not exactly the same, we can progress up from there. So if they made rude comments, but they didn't involve Kilt Boy, but they made rude comments to somebody else 2 years ago, and they were counseled, and now we're going to a reprimand, we use progressive discipline. So you don't want to go backwards in your progression if someone has reached the level of discipline that's necessary. So pay attention to that. Pay attention to that information that's in there about past performance and things like that, because that all went into influencing us as an agency to decide the action we took. So when it goes to a grievance committee, it gets, it can be a wild card. I've been on some pretty wild grievance committees. And so it can be challenging when it's you, and then you have 2 other people. I remember one I did for YDOT. That was my first grievance committee. And after I did that one, I was like, I'm never doing another grievance committee again. I was crazy. But that was before ANIHRD set the list of the third-party person, and I ended up with a third-party person that had probably a conflict of interest with the individual, but I didn't know it until after all the grievance was done. And then I found out he was a relative of the aunt or uncle or something like that. So that was an unfortunate situation that happened there, because then it was me against 2 people who were on the employee's side. So I really like it much better now that ANIHRD has the list of the third-party people who are those neutral individuals who can come in and have you from the agency or your nominee from the agency and the nominee from the employee, and then this neutral third party to be part of the grievance. That's much more helpful now than what it used to be. So that's been a very good change that ANI has put into place. So when you're on the grievance committee, just as you're looking through the documentation, pay attention to those things so that you understand kind of why the agency took the action they did. And then based on your review of everything, because then there'll be another letter actually, because there'll be the appeal letter to ANIHRD. So then you can look at the whole picture and then make your opinion on what you think needs to happen to resolve the grievance. So, where am I going from here? So, after the grievance committee, anybody have any questions about that? Anything anyone wants to share about grievance committees? Any other tips or tidbits on serving on a grievance committee? Sue's just smiling, so I don't know what that means. But yes, Tricia. Stacy's bringing you the microphone.
I would mention, and a lot of you already know, that we are in the process of hopefully revising this section and getting rid of the grievance committee, and we would like to get rid of the grievance committee. It doesn't mean we're going to be able to. One of the things we've talked about, if we cannot get rid of the grievance committee, that because of some of the issues that have been brought up today, having the grievance and appeals coordinator position possibly sit on each grievance, so that you would have the agency pick one, the employee pick one, and then the grievance coordinator sits on as the neutral party. That's one thing we have discussed, and we've been discussing that for about a year when Russ Webb was the grievance coordinator. So that's something to think about. We're trying to make it so somebody can realize there's a relative, there's an attorney. We've had it where an attorney's on there and advocating for the employee. It's not appropriate. So getting rid of the grievance committees altogether, I think is a good way to go, but we may not be able to do that. So we are open to talking about ways to shore up the grievance committee and not making it so difficult. So if you have any thoughts about that, certainly bring them up, and we will take that into consideration. So when we do go to public comment on this chapter, we can have maybe some options if there's a lot of pushback. Right now, I don't think WPEA is going to really push back on it. I've talked to them about it, so we'll see what happens. So, thanks.
Thanks. All right. So then following the grievance committee, the next step in the process, if the employee doesn't agree with the grievance committee findings or the agency doesn't agree, then you can take it then to OAH and go into that formalized process in a hearing, which I've had the pleasure of being in several now. So any questions about the grievance and appeal process? No? All right. Well, I'm glad I was nervous. I talked fast. I'm going to end a little early. Any other open discussion on documentation or discipline? Was this helpful? If anyone ever wants to practice, like if you're in that agency of 6 and you never write any, let me know, because we write them all the time. Or you can call Justin. Justin's in the back somewhere. We'd be happy to have you learn and practice. So just give us a call. I'm sure we can work out confidentiality issues, and you can practice on writing discipline. So seriously, really. All right, well, thank you very much.